All right, welcome back now. 23 minutes before 7 o'clock here on this Friday morning. I hope you're having a good Friday morning so far. Now, the Supreme Court of Appeal has ruled that SABC COO Hlaudi Motsoeneng be suspended immediately and face disciplinary action. The court dismissed an application by the SABC, Communications Minister Faith Muthambi and Motsoeneng. In its ruling, the court affirmed the powers of the public protector, saying she could not fulfill the constitutional purpose of her office if other organs of state second-guessed her findings and ignored her recommendations. The public protector had instructed the SABC to suspend Motsoeneng and institute a disciplinary inquiry. All right, well, let's welcome in studio now SABC attorney Titus Mchunu. It's good to have you here on the program, and welcome to Morning Live.
Thank you.
All right, let's I suppose start with the first question. Are we going to see our COO Hlaudi Motsoeneng arrive at work today?
The decision, maybe I must just explain, came out yesterday in the morning, and it is a complicated case. I must also specify that. It's complex in the sense that, in terms of its own facts, there's a lot of issues that need to be clarified within the parties.
Yeah.
So, at the moment, the SABC is studying its options to work out from the judgment itself what it would need to do. As the attorneys for the SABC, we've been requested to now go and review the judgment precisely to work out what the options that are available to it are. But the judgment itself, maybe I should also explain, is in two parts. It says discipline him.
Yeah.
And it says also suspend him. Now, this is a holding, or it's basically this decision confirms the decision of the lower court, the Western Cape. The Western Cape said suspend him within 14. It said suspend him, but in suspending him, it doesn't say suspend him immediately.
Okay.
It says within 14 days of the order of the court, you must formulate charges against him. Once you formulated the charges within those 14 days, you must then commence with the disciplinary action and complete it within 60 days.
Okay.
Now, you then sort of have about 74 days to work with there, depending on when you start. Therefore, as we speak now, there's no need, I would think, for him to leave immediately. The SABC needs to sit down and have a look at the judgment precisely, formulate the charges. If it decides to discipline him, and it doesn't decide to take it over back to the Constitutional Court, which is your next level. But at the moment, basically, we've been requested to look closely at the judgment, what it means in terms of implementation, if the SABC were to decide to implement.
Yeah.
If the SABC decides not to implement at the moment, what options are available to it? Maybe not to implement is a big word, but I'm trying to say what options are available to the SABC for it to take further. Obviously, there is the Constitutional Court that it can go to. If it decides to do so, what would be the issues that it needs to have a look at, or that it needs the Constitutional Court to review or to take a decision on by way of appeal?
Okay.
There are two aspects, as I mentioned. So you wouldn't appeal against the reasons for the judgment, but would appeal against the order itself, which is those two aspects I mentioned.
Discipline and suspension.
Correct.
Okay, but those are not now. It's within 14 days from the ruling. So there is still a little bit of time. I don't imagine after the ruling yesterday you've had a chance to engage with the SABC board as yet. We haven't, the SABC hasn't decided on its next step yet. Have you set up a meeting with them?
We haven't set up a meeting as yet, but we've been given the option to have a look at we've been given instructions to look at the decision closely and to advise the SABC of the options that are available to it. As I said, the options are to either, if it decides to challenge the decision, to take it up, and we would have to work out which of the aspects of the decision it would be challenging.
Yeah.
The suspension, I think, was one of the main ones at the SCA, and the challenge was really about the separation of powers, because the implementation of that particular remedial action, as recommended by the public protector, in order to implement it, the SABC would still have to look at its own legislative framework, which is the Broadcasting Act, the Disciplinary Code and Procedure, It would also have to look at things like your personnel regulations. It would look at a number of aspects in terms of what kind of misconduct, now within the SABC itself, it has to charge Mr. Motsoeneng with. The framework is already in the report of the public protector. Now, what needs to happen is, because this is a very thick report, it's not a simple report, it's very thick, and it's been in existence for a long time. One needs to look at it very closely and see how best to implement it within the SABC framework. Because the policy as well, in terms of the, if you're dealing with the, now let's take the disciplinary procedure, it needs you to also be fair to the employee in disciplining him, if you decide to discipline him. It's not necessarily a punitive procedure, and that stems from the Constitution, stems from the Labor Relations Act. There's a big framework that is outside of the framework of the Public Protector's regime, which is the Public Protector Act and the Constitution. But I think all the parties in this, especially the SABC as well involved, have an understanding and agree that the powers of the Public Protector, well, not the powers, I shouldn't say that, the decision or the decision of the report of the Public Protector, what is then regarded as the remedial action that she takes in terms of the Constitution, cannot be ignored by the institution that it's related to.
Yeah, because that, I think, was one of the big things to come out of that is to uphold the report. But
yes,
you mentioned that, I mean, there is more than just one party. It's not just the
That's
SABC.
correct.
There are three parties involved. So it's the SABC, it is our COO Hlaudi Motsoeneng, and of course it's also the Communications Ministry, represented by Faith Muthambi. Now, would there have to be cohesion between the three parties to decide on the next step? And that next step, I imagine, which we did hear, we were running in the news as well, we heard from the Daniel Manche, who is the advisor to the minister, that the Constitutional Court is the next step. So would it be all three parties going to the Constitutional Court?
There are three parties that were applicants at the SCA, as you've mentioned. But in terms of the decision to go further, then obviously the SABC is a separate institution. The minister oversees the SABC. Mr. Motsoeneng is an employee. Hence, they are represented by different sets of attorneys. All those sets of attorneys would have to sit separately with their clients and take a view. The case itself stems from the same facts. So the SABC would have to implement against Mr. Motsoeneng if it decides to implement. We would have to then sit with the SABC and decide. After we've advised them, the decision would have to be taken by the board itself. We would simply be advising on how best to deal with the matter. So the parties wouldn't sit down together. Each respective party has to sit with its own sets of attorneys and work out what needs to happen. But again, obviously, the issues are correlated.
Yeah. All right. One of the other issues that the court ruled is that an independent panel should be set up to overhear the disciplinary hearing against our SABC COO Hlaudi Motsoeneng. How could this be constituted? How would something like this work?
Again, that is now the aspect that is governed by the disciplinary procedure within the SABC. The SABC has to take on the order, look precisely if it decides to implement it as is without taking it to the Constitutional Court, and look at its own internal processes. How do you implement an order of this nature? Then the first thing that the presiding officer would want to see is that procedure. Everything that would be done would be in accordance with that procedure. It's not something that would stem from the court and would sit down immediately with the person. You would have to formulate the charges, looking at the public protector report. You would have to look at relevant other related case law, because that's a slightly separate matter now. It goes to, if there's an issue, it could go to the CMA, it could go to the Labour Court, and so forth and so forth. So that is an aspect, that is a process on its own. That's why the judge is saying, do it within 60 days. And if you cannot do it within 60 days, come back to the court and tell us why. Yeah. The DA would also have an opportunity then to say something if it feels that that is not in accordance with the expectations. But at this point, we have to sit down look closely at the wording of the case, the court order. It's a very long case in terms of the issues that are dealt with there. It is complicated. It covers a lot of grounds. It covers a lot of other courts. For example, you've got the Western Cape still dealing with the issue. Part B is going there next week on Tuesday. Today we are sitting looking at the judgment in Part A. Now, in between this, you also have what was called Rule 49, which was the immediate implementation of the suspension. That is hanging. It hasn't been finalized. If this is implemented immediately, the question is, what are the implications for the court sitting next week? That court is a lower court. Now, our justice system has what we call issues of certainty, ensuring that cases are run in a just manner. And in fact, that is one of the issues that the court itself here in this judgment specifies towards the end. It says multiplicity of actions or plurality of processes which relate to piecemeal approach in terms of running court cases in various courts at the same time dealing with the same issues is not to be encouraged. And I think that's a very critical issue that is coming out of this court case or the judgment. Yeah. So hence I'm saying it's not as simple as it may appear to be. One is to look at it very closely and look at what the court is saying. We are looking at the court at this judgment for its own, let's call it, for the facts that the court is dealing with. We're also looking at the implications that this has on the next case.
Yeah.
Now, the court itself says we have now overlapped and dealt with Part B. Part B to be dealt with by the Western Cape High Court. The Western Cape High Court has set aside 2 days, Tuesday and Wednesday, to hear the matter. Depending on what happens, their judgment may also be appealed. Now, ordinarily, from the lower court to go to the higher court. The higher court in that instance would have ordinarily been the Supreme Court of Appeal. Now, can you still go there if the matter has already been considered on the facts? And ordinarily would also go from there to the Supreme Court, to the Constitutional Court. So there's a lot of issues that we believe one has to have a look at, what the implications are going to be on the justice system. Okay. And issues of fairness, running the case and ensuring that all the parties are properly represented.
All right, Titus, thank you. Thank you very much for coming in and giving us a little bit more understanding as to this Supreme Court of Appeal ruling. And as you can see, it's not just a simple issue. There's so much more to it, with still other judgments coming in from other courts around the country. But the next step, if this is the decision, it could go up to the Constitutional Court after the Supreme Court of Appeal ruled that SABC COO Hlaudi Motsoeneng be suspended immediately and face disciplinary action. SABC attorney Titus Mchunu, thank you. Thanks always for coming in and chatting to us here on the program.
Thank you very much.
All right.